Hi, and welcome to ProfDale's Property Video number 29. I'm your host, Dale Whitman. In this video, we're going to cover housing discrimination. Is discrimination illegal? Well, if you ask most people, they would just say yes, but it turns out it's a little more complicated than that. Whether discrimination is illegal depends on a couple of factors. First, what's the basis of the discrimination? Is there a law prohibiting discrimination on this basis? And second, what type of decision is being made? In this video, we're going to talk about housing decisions and how discrimination laws affect them. Under the Fair Housing Act, a federal act, what are the illegal bases of discrimination? Well, there's a whole list of them: race, color, national origin, religion, sex, familial status, which is defined as having a household member under the age of 18, and being handicapped. All of those are illegal bases of discrimination under the Fair Housing Act. The Fair Housing Act does not cover discrimination on some bases that you might expect it to. For example, it doesn't cover discrimination on the basis of sexual orientation or gender identity. Other bases of discrimination not covered by the Fair Housing Act include personal appearance, source of income, place of residence or business, genetic information. Now, there are some state and local Fair Housing Acts and ordinances that do cover some or all of these bases of discrimination. So you have to look at both the federal law and the state law to get the full picture. But the federal law doesn't cover the ones listed on this slide. Now, if a person is providing housing, what sort of decisions by that person will violate the Fair Housing Act if they involve illegal bases of discrimination? Well, here are some of the decisions in which discrimination is illegal: selling or renting housing, fixing the terms, conditions, or privileges of rental or sale of housing, making, publishing, or printing a notice, statement, or advertisement about housing, representing that a dwelling is not available, and the last one is sometimes called blockbusting, that is, inducing a person to rent or sell by representing to that person something regarding the entry into the neighborhood of persons of a particular race, color, religion, sex, and so on. Blockbusting was a huge problem in the early days of the Fair Housing Act, as realtors and property flippers would come into a neighborhood and represent to them that minorities were moving in, get them to sell their houses at low prices for fear of the minorities coming, and then resell the properties to the minorities at much higher prices. In reality, the overall prices of the property usually went up, but the turnover was enormous. The Fair Housing Act also covers handicap discrimination. Handicap discrimination includes the following decisions: refusing to permit reasonable modifications to afford handicapped persons full enjoyment of the premises. Now, the handicapped individual has to pay for the modifications, but the landlord has to allow the modifications to be done if they are reasonable. Refusal to make reasonable accommodations in rules, policies, practices, or services that are provided with the housing. Failure to design and construct dwellings to make property accessible to handicapped persons. Now, that's only prospective, but it would apply whenever new housing is built or whenever old housing is rehabilitated, that it has to be accessible to handicapped persons.
By the way, you should be aware that the language of the Fair Housing Act is considered out of date and obsolete by persons in the disabled community today. They would have a strong preference for the use of the term disability rather than handicap. Today, we refer to persons with physical disabilities rather than physical handicaps, and intellectual disabilities rather than mental handicaps. Of course, when making a legal argument, you'll need to use the language of the statute, and we'll do so in this video. But you'll want to be sensitive to the preferences of clients and other members of the disabled community in conversations with them.
Lending discrimination is also covered by the Fair Housing Act. It prohibits discrimination on the prohibited basis in lending for housing, such as mortgage loans. And this includes refusing to make a mortgage loan or providing other financial assistance for a dwelling, refusing to provide information regarding loans that are available, imposing different terms or conditions on a loan, such as different interest rates, points, or fees, discriminating in appraising a dwelling, and conditioning the availability of a loan on a person's response to harassment in connection with the making of a loan. Discriminatory advertising is also prohibited. The Act says it's unlawful to make, print, or publish any notice, statement, or advertisement that indicates any preference, limitation, or discrimination based on one of the protected groups. Now, there are some exemptions in the Fair Housing Act. There are two of them. One of them involves only single-family residences, and the exemption says that a single-family house is exempt from the Fair Housing Act if it's sold or rented by the owner, provided that the owner doesn't own more than 3 single-family houses, the owner doesn't use a real estate broker, the owner doesn't use the services or facilities of anybody who's in the business of selling or rental housing, and any advertisement used mustn't indicate a discriminatory preference. The other exemption involves rental units. A unit in a building with no more than 4 dwelling units is exempt if the owner occupies one of the units as his or her personal residence. Now, here's a series of problems to illustrate some of the ways the Fair Housing Act works. In the first problem, the landlord is renting to a disabled tenant, and the tenant has difficulty opening the existing storm door on the property, and therefore the tenant would like to put in a new storm door. The landlord refuses to pay for it, but that's okay. The landlord doesn't have to pay. So the tenant puts in a new storm door. The unit is a unit in a condo, and the condo association says the storm door is aesthetically different than the other storm doors in the project, and we demand that it be removed. The court held that the condo association was in violation of the Fair Housing Act. The landlord was not, because the landlord did not stop the tenant from putting in the new storm door. But the condo association, even though it wasn't the owner, was still in violation of the Fair Housing Act. Here's problem number 2. The landlord refuses to rent to a tenant because the tenant's primary source of income is Social Security disability payments. The court held that this was a Fair Housing Act violation because the landlord was discriminating against persons based on their disability. Now, you might ask, what about other kinds of income sources? Could a landlord discriminate against them if they had nothing to do with disability? And discriminating against other sources of income, such as public assistance, is not illegal under the Fair Housing Act. However, under some state or local laws, discrimination based on source of income is illegal. So you have to check both the federal and the state law. Problem 3. The tenant has a lung disease and wants to move to an apartment that's away from nearby apartments that have smokers in them. The apartment the tenant is living in gets infiltration of smoke from the neighboring apartments that have smokers in them. The landlord says, well, I'll let you move and I have a unit available for you, but there's a fee of $105 for the move. The court held the landlord is required to waive the fee as part of reasonable accommodation to a tenant with a disability. Problem 4. The apartment manager expresses a romantic interest in a female tenant. When the apartment manager is rebuffed, he then becomes abusive and he denies her maintenance requests. He won't maintain her apartment because he's angry at her. The landlord is held here to be in violation of sex discrimination, and there are 2 different theories that apply. One of them is quid pro quo, where the landlord is conditioning the providing of a service upon sexual favors from the tenant, and the other is a hostile environment. In other words, both of these theories that are taken from employment law apply in fair housing law as well. Problem 5. Here's an advertisement: trailer for rent, great for single or working couple. All utilities paid except for propane gas, $175 a week. Now, the question becomes, does this express a preference for households with no children? That would be familial status discrimination. Remember, familial status means having a child under the age of 18 in the household. The phrase great for single or working couple might be very well construed to discourage families with children from applying, and therefore it could be held to be a violation of the Fair Housing Act. In problem 6, there's a note on the bulletin board. I am a white Christian male seeking a roommate, no smokers. It's a similar problem. Does the mention of the advertiser's sex, race, or religion indicate a preference for the same sex, race, or religion? And it might very well be held to do so, and therefore to be a violation of the Fair Housing Act. Now you'll notice that this is an advertisement by a single individual. We tend to think of the Fair Housing Act as applying to landlords and realtors, people who engage in large-scale provision of housing. But it clearly applies even to someone who is providing only one dwelling unit, or in this case, only part of a dwelling unit. By the way, if a preference for sex is stated, that is permitted where the sharing of living areas is involved. So it's okay for a single male or female provider of housing who's going to live in the same dwelling unit to express a preference for a male or female. What about dangerous tenants? A landlord might say, well, I don't want to put a tenant in here that would be a danger to other tenants. Housing under the Act may be denied legally to an individual whose tenancy would constitute a direct threat to the health or safety of other individuals or result in substantial physical damage to the property of others. So either personal risk or damage to property can be the basis for turning down someone for housing. Now the question becomes, what about people who have a history of criminal conduct or violence in the past? Can they be rejected? Suppose there's a black applicant and he has the following variations on a criminal history. First, suppose he's been convicted of an aggravated assault in the past year. Second, suppose he was arrested for marijuana use, which is not a violent offense, 5 years ago. Third, what if he became a registered sex offender because of a conviction for statutory rape, that is, sexual activity with a person under the age of 18 in most states, and that occurred 10 years ago, when the applicant was probably quite young. Well, what about these variations? Must a landlord take them into account? Well, the Department of Housing and Urban Development's General Counsel took this issue under advisement and issued a letter of guidance in 2016 about it. And here's what the General Counsel had to say. First, that blanket exclusions of anybody who has any criminal conviction are simply not acceptable under the Fair Housing Act. They're too broad. There's too much possible variation in the conduct of people who have a criminal conviction. Housing providers, according to the General Counsel, have to consider how much time has passed since the offense, the age of the individual at the time of the offense, whether the crime indicates a risk to safety or harm to property. For example, the marijuana offense we talked about on the previous slide is obviously not a violent offense and probably doesn't indicate any risk to safety or property at all. Whether the individual has a good tenant history after the offense, in other words, a long time has passed and they've cleaned up their act. So all of these decisions must be done on a case-by-case basis rather than saying that just because someone has a criminal conviction, they're not permitted to come into my housing. Now, familial status discrimination can be quite tricky. Familial status, remember, means having persons under the age of 18 in the household. The idea is to prevent discrimination against families with children. Housing providers are allowed to impose occupancy restrictions. The occupancy restrictions might be based on reasonable state and local codes, and it's quite common for zoning and housing codes to restrict the number of persons per bedroom or the number of persons per square foot in a dwelling unit. They can also impose reasonable occupancy restrictions based on the decisions and policies of the housing provider. 2 persons per bedroom is presumptively considered reasonable, but the presumption is subject to rebuttal. If you had a very large bedroom, for example, that had plenty of room for 3 beds in it, then a 2-person per bedroom restriction might be considered unreasonable. So the provider of the housing has got to consider whether their policies, as well as the policies provided in state and local codes, are reasonable or not. You might wonder about senior citizen housing. There are special rules for housing for persons over 55 years of age. Those rules are fairly complex and we don't have time to cover them in this video, but they do allow the creation of Sun City type developments where individuals over 55 can live and people under that age cannot. What about the following landlord rule? Children under the age of 18 are not allowed in the pool or pool area at any time unless accompanied by their parents or legal guardian. Now remember, the Fair Housing Act applies not just to the dwelling unit, to the services that are provided along with the dwelling unit, including the pool. And this is clearly a rule that is discriminatory against children. The landlord might say, well, this is designed to protect the safety of children. But it's certainly possible that there could be children under the age of 18 who are perfectly safe in the pool area, whether they're accompanied by their parent or guardian or not. We need to talk about the issue of disparate impact. And what do we mean by disparate impact? Well, it's a policy imposed by a housing provider that isn't by its terms discriminatory. It doesn't say anything about race, religion, sex, or national origin, for example, but it has the effect, the impact of bearing more heavily on a protected class than on the rest of society. So could a policy of that sort violate the Fair Housing Act? Let me give you a couple of examples. A condo association prohibits its owners from renting out their units. Now you might say, what does that have to do with the Fair Housing Act? It's actually a very common type of rule in condo associations. However, it has the effect of reducing the supply of rental housing in the particular city or market area. And because more minorities than whites are renters, it has a heavier impact on minorities than it does on white citizens who might be looking for a place to rent. So there is a disparate impact there. One court in Indiana did indeed find that this violated the Fair Housing Act. Here's another example. A mortgage lender decides to increase its credit standards. So it announces that it will only make loans to people with FICO scores above 750 and housing payment to income ratios below 25%. Those are very high standards. That means that the housing provider will get only very well qualified applicants for their mortgage loans. But it also means that because more minorities than whites tend to have lower FICO scores and higher housing payment to income ratios, they're going to screen out more minorities than white applicants if they adopt this policy. The standard analysis for these kinds of disparate impact issues is taken from employment case law, from the Fair Employment Act of Title VII of the '64 Civil Rights Act. And here's the analysis in a nutshell. First, the plaintiff has the burden of showing that there is a disparate impact caused by the housing provider's policy or announcements. Then the burden shifts to the defendant. And the defendant, the housing provider, has the burden of showing that its policy has a legitimate, non-discriminatory objective, a legitimate business objective. Then the burden shifts back to the plaintiff, and the plaintiff has the burden of showing that there is a viable alternative method of achieving the defendant's objective without a discriminatory or with a lesser discriminatory impact. Now, the question before us is, does the disparate impact theory that we've just talked about apply to the Fair Housing Act? The Supreme Court resolved this question and decided that the disparate impact concept does apply to the Fair Housing Act in the case of Texas Department of Community and Housing Affairs versus the Inclusive Communities Project in 2015. Now, the decision was a 5-4 one, and the court a majority didn't seem to be completely satisfied with the decision that they'd made. They were very obviously worried about how the disparate impact concept would apply to the Fair Housing Act. So they imposed some limitations on the use of the disparate impact theory. First, they said the plaintiff has to show the defendant's policy is the cause of the disparity. In other words, causation is critical. It isn't enough just to show that there is a policy and there is some disparate impact. You've got to show the policy causes the disparate impact. The causation is essential. Second, they said that defendants, housing providers, have to be given leeway to state and explain the valid interests served by their policies. For example, in the condo situation we talked about on the previous slide, where the association prohibited the renting of dwelling units by its owners, the condo association, if given that leeway, might very well be able to show that renters in a condo project don't take care of their units as well, they don't pay the assessments, they generally don't follow the rules. In other words, they cause losses of value to the other unit owners, and therefore they're undesirable in a condo project. Now, I'm not sure that all of those assertions are true, but if the leeway is given, they might be able to show that, and the court said they have to be given that sort of opportunity to present evidence of the valid interests that are served by their policies. Finally, the court said the plaintiffs have to show, remember the burden shifts back to the plaintiffs, that there is an available alternative practice that has less disparate impact and still serves the defendant's legitimate needs. In other words, if this is the only policy that will serve the defendant's needs, they're allowed to pursue it and retain it even though it has a disparate impact. And it's the burden of the plaintiffs to prove that there is an alternative that will still serve those needs. Well, that wraps up video number 29 on housing discrimination. In our next video, we'll begin a series of videos that deal with covenants running with fee simple interests in land. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.